So sorry, I'm missing one bundle, and I just see whether I've left it outside, which I may have done.
My lords, may I ask you, can I have 5 minutes at some time this afternoon to just say a few words? It has taken 10 years out of my life, no less. I would like to make just a few points.
Yes, Mr. Westway, I think it might be better to let Mr. Salaman have his 5 minutes now, and then you finish, and then I'll ask Mr. Garland, but only Mr. Garland, to reply at the end. The tradition in these courts, if you were a QC and a junior, is that you'd each be allowed to speak originally, but then only the QC would be allowed to speak in reply. So, all right, Mr. Salaman, that's the deal. You have 5 minutes now.
My lords, may I ask for your patience? I might say things I'm not supposed to say. But you know, the background to this is because we've had so much trouble along the footpath. And this is just one photograph of an injury I sustained. It was the local Perford and Byfleet committee. They wrote down, Phil Wilson wrote down that he had met me and that I had tried and hoped for that we could find a solution so that I could be safe. And Sir Patrick Elias, makes the point. And I'm afraid to say it cannot be disputed, and I certainly won't be accepting it, and whatever's necessary to be done will be done. Sir Patrick said that we were claiming that it was a nuisance per se, because it was less than 2/3 of the recommended preference heights by the British Horse Society. If something is 2.3 meters high, it must by definition be a nuisance if the recommended height is 3.4 for riding, 3.7 for riding, and 3.4 a minimum for leading a horse. By definition, it has to be a nuisance, as otherwise there's no point in having these recommendations. The purpose of the recommendations are not for aesthetics, they're there purely for safety reasons. Can I just show you this? This is a tape measure, and I'd just like to. This here is 115 centimeters. I've got it on the floor. So in other words, the height of the tunnel, this is 115 and it's double this height. So it would be about here, the height of the tunnel coming up. So it's clearly that if I had the privilege and the pleasure of showing you three at the end of the lane and said, let's walk up here now. If a horse come down, there are loads of places. It's not 5 meters. You would have nowhere to go. It has already inhibited pedestrians who had this one place where pedestrians could walk in safety, especially the elderly. And I've already said to certain people, don't come down the footpath with a pram, just in case there's a horse. You know, it can cause serious injuries. The last couple of things I would like to say to this. I know that Sir Stuart-Smith there said that you have the opportunity to answer at a public hearing to put your side of the story. I want to know why Surrey County Council could interview 10 people, yet the oldest resident on the footpath, who was completely against it and lived next door to one of the persons, they took a witness statement, why it was for Mr. Salaman, who is the landowner, why they couldn't take one statement. You have to treat people fairly. You know, it's just not acceptable. The only thing I think I'm going to be left to do is to go to members of the public, because I know there were signs there, and I know there will be a record of signs there saying no horses, no cycles. Mrs. Woodruff herself said there was. The only horse user there. And lastly, I'd like to point out, because we got all the aerial photos for the different kinds of years, going from the 40s, aerial photographs, it has never been 5 meters. And as you could clearly see from the
width.
5 meters width, right? And as you can see from coming to my house, looking outside the house, at best it must be 10 feet along the front of the house. My lords, if you can do something for somebody, it's a pleasure to do it, to facilitate somebody else. But I'm in constant fear. I walk around all the time. I don't go outside the house without a camera, because after all, as the three of you know, Mr. Drummond, who had a walking stick, this all started because he was attacked by somebody coming down with a motorbike. Mr. Collins, Judge Collins, who I must say thank you to, he's a great man, right? He said that what I was trying to do to make myself safe was reasonable. But Surrey County Council had this lèse-majesté attitude. And so I think, you can't imagine what this case has cost me, but I will never give in. Because I'm not threatening you, obviously. I'm just saying that the world looks up to the value you give yourself. And if you know something is wrong and you put up with it, then it's your fault. Can I say thank you for your patience? Thank you for your patience.
Thank you very much. You stuck to your 5 minutes. Mr. Westerway, back to you.
Thank you. My cogitations over lunch and also a document that was sent through from the client who's watching this have provided me with some documents to hand. So I'll pass these to Mr. Salaman and Mr. Garland.
Oh, I got it right. Yeah,
Great. And I've got copies for the bench. While that's happening, I'm conscious in a discussion that ranges a little bit wider than the facts of this case. We're talking about hypotheticals of what might happen with cycle use, horses who didn't use it. My submission is that Whitworth is quite clear that a bridleway can be, I'll come to those in a moment, that a bridleway can be dedicated on the basis of cycle use alone. In this case, though, and I think this is to put the claimant's case for them, if it were the conclusion that the inspector was bound on the evidence and had to find that there was a public nuisance from any equestrian user of this way, I don't think seriously we could seek to uphold this order. So that's the reality we're in, and what I don't want to do is go down the hypothetical cases that don't really arise.
Could you just repeat that? If there was a public nuisance from any...
So if it were the case that any equestrian use of this way would necessarily give rise to a public nuisance, then I don't think that we could seriously argue that this order should be made. And especially because part of the use relied upon was equestrian use. What I've handed up are two things. The first is a better copy, I hope, of the photograph, and it shows, I hope, a little bit more clearly the distinction between that sort of lower area and the upper area that your lordships were asking about. That's looking from the north, as I understand it, and I think it's effective. I think it's the same photograph that the court was taken to by Mr. Garland.
We've seen it before, but not in colour and rather more blurred. But yes.
Yeah.
So I don't need to say any more about that, really, other than I think it's a little better. Mine was hopelessly poor, actually, and I maybe should have anticipated that. But my clients, seeing the trouble we were having, sent that over. I didn't realise it existed. The next point is slightly more complicated, and again, I don't want to spend a very long time on this, but I also have to say at the outset, I've not investigated this point fully. So it's the question, my Lord Justice, been asked about controls that may be able to be imposed upon a bridleway to require horse riders to dismount and lead their horse through an underpass. I can't find a conclusive answer to it. On the face of it, the controls that I referred to would not cover that situation, but I'll just quickly take the court through what I've found, and if the court wishes, I can attempt to come to a more conclusive answer after the hearing. I don't think I can promise more, but certainly I'm not going to submit that there are such controls.
Well, I have to say, myself, I mean, it's an interesting point, but I don't think if you're not able to give an answer, and I'm not being critical about that, I can see it's quite a tricky point, it doesn't arise in this case. I think whatever happens.
The short answer is, and is the court assisted at all by me showing what powers are available?
Well, just give us a quick overview of these sections of the Road Traffic Regulation Act. As Sir Patrick said, it probably won't decide the case, but having asked the question, I'd quite like to know what the answer is.
Well, I would like to know perhaps more conclusively what the answer is, but I think it's this. Section 1 is the power for traffic regulation orders, and you'll see the wide range of reasons for which a traffic regulation order might be made at Section 1.1.
What is a road?
A road is defined, I've given you Section 142, that's the third of the pieces of paper, and on page 3 of that, this is rather circuitous. Road is defined any length of highway or any other road to which the public has access.
Wait, where do we find that?
So it's page of Section 142, it's on page 3.
142, right.
But highway doesn't include footpath and bridleway, does it?
They are.
They are.
Highway is any a highway includes footpaths and bridleways. It's any public right of way.
So for the purposes of Section 1, this is a road. Yeah. And so there are wide powers to make provisions for avoiding danger and all that. Yes.
So it doesn't get easier, but yes, that first point we're through. In principle, the purpose of avoiding danger, a traffic regulation order could be made. The limitations in Section 2, what a traffic regulation order may provide, there's two provisions here. Subsection 1 relates to vehicular traffic, which clearly doesn't include equestrians. Subsection 3 relates to pedestrian traffic. The uncertainty is that traffic is used as a word for all types of road user in various places, and I simply don't know, without looking into it a little further, whether controlling equestrians could come within subsection 3, but on the face of it, it doesn't. The one that control pedestrians.
It would be very odd if that was said, that a traffic regulation could regulate any vehicle, any pedestrians, but horses can do whatever they like. All right.
Well, that's the thing. So it may be that statutory interpretation would lead one to include horses within that, but I can't go as far as that.
All right. Thank you very much.
There was two other points. I think over lunch I just wanted to pick up on. The first one's a separate point really about Mr. Williams, if I could deal with that now. Some criticisms made of Mr. Williams' expertise in this area. We know Mr. Williams is the Countryside Access Officer, or had been since at least 2014 for Surrey County Council, and we know that he's a member of the Institute of Public Rights of Way and Access Management. Institute of Public Rights of Way and Access Management is the full name of IPRO. That's a professional organisation, and it's a membership organisation.
Well, I'm sorry, my lord, but
None of this information was before the court.
Mr. Garland, please don't interrupt. Mr. Westerway is entitled to make this. Mr. Salaman made an attack on the character of Mr. Williams, and Mr. Westerway is entitled to reply. Yes, Mr. Westerway.
And that's the professional body that represents individuals employed in the management of rights of ways in all 4 jurisdictions, England, Wales, Scotland and Northern Ireland. It's a membership organisation, and it has associated with it codes of practice. So the planning inspectorate's position on it is that it recognises membership of IPRO in the same way as it recognises membership of, say, the Town and Country Planning Institute. So it's clearly not wrong for the inspector, who is himself a member of IPRO, to give weight to that membership. And it's not really a relevant point in my submission that we don't know whether the inspector is, in quotes, an expert on horse riding, or Mr. Williams is an expert on horse riding. What we do know is that they have practical experience and qualifications about public rights of way that includes, as one of its major components, horse riding. And the last point was, my Lord, Lord Justice, sorry, let me just try and remember the point. It was the point about symmetry. Yes.
Yes.
On symmetry, I don't know if any. I didn't really want to go through TW logistics unless I needed to, but I think the essence of the point is that with a definitive map modification order, it's not and never should be conceived of as the creation of new rights. It's the recognition of rights that have already come into being. And indeed, I think in a recent case that my Lord Justice Beam was involved in, the rights come into being at the beginning of the period in common law dedication. Barlow and Wigan
Yes.
was a case
Yes,
that covered that
I
point.
remember that.
So it's very clearly something that's already happened that is recognised by means of an order. It's very different from a creation order or diversion order. Indeed, there are such things as cycleway orders. It's not the same sort of thing.
So one deems it was a bridle way from the first use. Is that how it works?
It would be from 1983.
Yes.
So there's no trespass because all of those, all of that use would have been covered by the implied dedication. My Lord, so I don't quite know where to go exactly next. I think I wanted to go to the order decision, if I may.
I'm sorry, before you do that, I'm sorry to interrupt you, but I'm trying to think of how that works with the concept of capacity. If the status as a bridleway goes back, and then one is asking, was there capacity to recognise that? One would have thought the capacity would be at the same point. But at the point where the user starts, it's difficult to know what the flow of traffic is going to be. I'm not quite sure how one applies a symmetry principle, as it were, in that context.
Well, there's an element of fiction here, whether it's Alice in Wonderland fiction or not. There is an element of fiction here, and one is reading back from what happens afterwards. In any event, the dedication is, and it's fairly well settled, is said to be at the beginning of the period it's relied upon. But it's
And is it evidenced by what has happened thereafter?
Evidenced by and what's happened before today, necessarily. So that's what definitive map modification orders are doing, and this is why I submitted in principle. They expect a continuation in the same vein, because one does not, with definitive map modification orders, have any ability to impose conditions as to surfacing of paths or changing anything. It's very possible to recognise a footpath, for example, in a definitive map modification order process that's really quite overgrown.
But provided the burden is on an objector, it's not an irrebuttable presumption, is it? I mean, if I don't know how you do this, but if an objector satisfied the inspector that the consequence of recognising it as a bridleway would be that obstructions would be taken down, and however it's done, the flow would greatly increase to such a level that it constituted a public nuisance. That would be open. That would be a line of course, of an inquiry that would be open to objectors, wouldn't it?
Not unless that had a bearing, for some reason or other, on the previous use. So the future, the prospect of future changes that may be very problematic simply have no role at the definitive map modification order inquiry. There is another case.
That's why in Sheringham it says it's always been a nuisance. It couldn't possibly be a dedication because it was a nuisance.
From its inception.
From its inception.
Just other words in Sheringham. And I may not need to go through them, but all of the cases on public nuisance are very clear that they're talking about the quality of the use that happened and was relied upon, not some speculation about what may happen in the future. The matter did arise in not entirely different terms in a case called Lee, which is before the court at tab 15. This is the High Court, His Honour Judge Helling. This was, as I say, has some similarities because this was also a challenge under the same statutory provisions to a definitive map modification order of a existing footpath that recognised it as a bridleway. And a number of arguments were made. I think where I want to draw the court's attention to the inspector's conclusions on the use can be seen at para 13. So he's finding a significant level of regular usage by horses.
Did you say paragraph 13? No?
It's para 13 of the judgment, yeah, paras 23 to 26.
Yep.
And then the inspector went on to deal with some other issues, and at para 21, under the heading Other Matters, so over on page 6, para 21, to a health and safety issue. And if your lordships just read para 21 through to 24, it's probably far better than me at reading it out for you. there's some analogue there with this.
Hang on, I haven't read 24.
To the end of 24, did you say?
Yeah.
It's that's the critical bit.
Does it come to this, that because the way that implied or inferred or deemed dedication of a highway works, because it's retrospective, it's based on past use. So what the inspector's decision amounts to a finding that Muddy Lane has become a bridle way. It's declaratory, really. And future use can't affect that question. But if it did become, if it has been lawfully declared to be a bridle way, and the result of that is an increase in use, then there may be management powers available to the county council to restrict that use, or there may not, but that's the way the law works, not by saying that the implied dedication can be somehow avoided by saying, well, if you declare it to be dedicated, there will be an increase in use.
And so, on that analysis, the evidence about changing standards has to fit into an argument that they show that it was a private nuisance from the start of the period that is being treated as the dedication.
Public.
Yes, and I entirely endorse the observation from this morning from the bench that it can't be that standards change and that somehow has a detrimental effect on the existing network. In relation to the management powers of a local authority, clearly they go beyond simply those traffic regulation orders that I refer your lordships to. Local authorities can erect signs, they can improve highways. Ultimately, if they need to, they can divert and change highways. So they can do an enormous number of things if it's appropriate in the public interest to manage highway use.
Is this what the inspector meant, do you think, at paragraph 51, when he says there's scope for the council to maintain the route in a manner that would accommodate the different types of lawful use?
That's my reading. My reading of it is that he was thinking of something similar to the inspector in the Lee case. And one can see, perhaps the most obvious thing would be signs in terms of management. The council could erect signs that would explain hazards if they consider hazards did arise. The council could widen the route. The council could.
It's a bit difficult, isn't it?
Would
The subway.
in the subway it'd be difficult, but
Yeah.
to the side of the subway they could if they thought there was a need to widen the route to accommodate, for example, mounting blocks. One can imagine all sorts of ways in which these issues could be resolved, but surely the simplest would be signage if an issue arose.
I think it is important, isn't it, if I hope I got this right, that in essence, when we're looking at public nuisance, we're doing it to ask whether the landowner had capacity. So if the landowner had capacity at a particular point on the user that is before the inspector, as it were, and one can see that it's very difficult to see how an increase in user can retrospectively change that position and say that they didn't have capacity. That must be critical, mustn't it? You can't say after the event, well, they did have capacity then, but retrospectively they didn't, as it were.
I think that is the correct legal analysis in my submission, and that's clear. We haven't gone through it very much, but that's clear from the case of Bakewell and Brandwood, which is, although it's obiter on this point about public nuisance, I think I've put it in my skeleton argument, it's the leading authority on this point, but it's certainly the highest level authority on the point. It's maybe worth just picking up one or two references in that case before I turn to the inspector's decision, if that's acceptable. But we have that at tab 10. So the leading judgments, or leading speeches of Lord Scott. Lord Walker's is useful as well, though, and I'd recommend that the court look at that as well. Lord Scott. It's from para 10 and onwards. The reason the public nuisance points are over to here is because they didn't arise on this particular case. This particular case was about some statutory powers. And the statutory powers were both, had the proviso without lawful authority, where lawful authority is understood to mean the authority of the landowner. So something that can be entirely dispensed by the landowner without reference to the public interest. And public nuisance comes in the discussion of post-Hanning cases, Hanning and top deck, at para 40. Para 40 itself is discussing other cases. It's para 41 that moves on to one of the cases that was half distinguished, Hereford and Worcester, half disapproved, I should say. And in that case, that's Hereford and Worcester, Lord Justice Stuart-Smith had said public rights cannot be based on long use where use is prohibited by statute, referring to these statutes with that proviso. That bit was overturned. Then he also said, or he said also, that the user relied upon for the presumed dedication would have constituted a public nuisance. And Lord Scott expressly approves that in para 42. So the common law crime of public nuisance is one for which there's no dispensing power of the landowner. So it doesn't say without lawful authority. A landowner cannot give a member of the public on his land the right or ability to cause a public nuisance. That's the distinction between public nuisance and those other provisions that were directly in discussion. The discussion by Lord Walker, that's his speech is para 48 and following.
So in this case, the offence which the house owners had been committing by driving over the common land was not the common law offence of public nuisance, but a more specific offence under the Highways Act or something.
There were, I think it was Law of Property Act and the Road Traffic Act.
Right, Law of Property Act, right.
And look, the discussion in Lord Walker's speech, para 48 and following, he discusses various cases of para 50 and onwards, and then distinguishes them from the specific example of the Law of Property Act 1925. And it's paragraph 50 I'll just draw attention to, because that makes it clear that the principal at play is competence of the grantor. He's discussing a number of cases relating to slightly different areas, where companies simply wouldn't have powers as trustees for the public to do the things that they might otherwise have done had they been free individuals under prescription. And it may be useful just to look at paragraph 56, which is where Lord Walker sets out what he calls the exceptional or extraordinary feature of the particular statutes that the court was looking at here. That's in Bakewell and Brandwood. If I can, to paraphrase that, the reason why it is not within the capacity of a landowner to permit someone to commit a public nuisance on his land is because of the public interest. A landowner simply cannot do that. So in a way, as the court recognises in Bakewell and Brandwood, this is a principle of public policy.
You've said that if the usage were to increase, that there would be traffic management powers that could be exercised. But is there any other way in which somebody could go back and say, or an authority could say this should no longer be a bridleway? It should go back to being a footpath.
Good question.
There's powers to divert and extinguish rights of way in special circumstances. Powers of diversion may well be satisfied if an alternative route can be provided. And the justification for a diversion order might well include management problems on the existing route. And one might perhaps imagine, if this became a very popular, quite important route for horse riders, that the local authority might responsibly think, well, this is an important route, we need to move it so that it doesn't cause those problems.
And extinguish too.
Extinguishment is a stricter test. It has to be shown there's no need for it before you can extinguish it. So that would be stricter. But diversion powers, it depends a lot. And there are, again, strict tests for diversion. This is within the Highways Act 1980, I think, section 118 and 119. So I think it's fair to say there are powers, but they have to be exercised in relatively strict circumstances.
Yes, thank you.
There's a long judgment from Lady Hale on page 13. Should we be interested in how it continues?
I think, my fault entirely. On the copy I had, it was rather cut off. On page of
After paragraph 61,
on page 549, I just have a short judgment of Baroness Hill.
okay.
Am I looking in the wrong place? Or?
Well, maybe actually I've got two copies of these authorities, but in the version that I had before we came to court, 61, paragraph 61 is I would therefore allow this appeal.
Yeah.
And paragraph, it then says, my lords, which is not otherwise particularly informative.
I apologise. I think it's entirely my fault.
Okay.
I've got the appeal cases text
Yes.
Yeah.
in which
So
Lady Hale, at about the middle of the page,
Agreed.
says, I agree that the appeal should be allowed for the reasons given by Lord Scott of Foster.
Thank you very much.
It's, because of various things, this bundle, a couple of the authorities weren't proper reported versions, and I only spotted it yesterday, so I apologise for that. I think that's probably why. My lords, I don't think I have a lot left. Really, I set out my response in the skeleton argument, but it flows from the discussion we've had. The question is much more limited than the concern, and it's very common in definitive map modification orders for there to be concerns about future management, and the short answer to them is they aren't relevant. The appellants in this case seek to translate that concern into a point of substance, the public nuisance point, but it doesn't stand up to scrutiny on the facts. It's not consistent with the evidence that was actually before the inspector. And he was entitled in my submission, especially given that he had a 5-day inquiry, 2 site visits, and lengthy written submissions before him, not least from the appellants, to dismiss it in relatively short order. It's very well established with inspectors' decision letters that they need to be read in context, and it be recognised that they're addressed to an informed audience who knows the debate that happened at the inquiry, the submissions that were made. And in my submission, when the inspector says in the critical sentence, para 51, there is a lack of evidence to substantiate the objector's claim that the designation of the route as a right-of-way constitutes a nuisance for pedestrians, that was enough particularly when one looks at what the objector said to the inspector, and this is where the judge's analysis in my submission is correct. Because what he does is he goes to the submissions that were made to the inspector and asks, do they justify that conclusion? And concludes that they clearly do. Well, I'm conscious there are points that I've not picked up on. There was one point simply of detail about the consistency guidelines I wanted to come to, but other than that, those are my submissions, and you of course have my submissions in writing in the skeleton argument, but if your lordships have any questions on any points or there's points I've not covered, I'm of course very happy to answer those.
Thank you very much, Mr. Wood.
If I can very briefly deal with my consistency guidelines.
Yes.
This is very much for the avoidance of doubt, and I
Yes.
don't make any substantive point on it because it's not raised by the appellants. But simply a point of fact is that the consistency guidelines, I said in my High Court skeleton argument, to which I refer you by reference in my Appeal Court skeleton, that they are no longer updated. That was the case back in 2019. It had been updated in March 2021, but the material paragraphs are in the same terms as the 2016 version that you have in the authorities bundle at tab 18. So unless anything arises from that, those are my submissions.
Thank you very much, Mr. Wood. Now, Mr. Garland, no need at this stage to repeat anything you said this morning, but if there's anything Mr. Westerway has raised which you didn't deal with earlier, to which you'd like to respond?
Yes,
please
there are
do.
just a few points.
Yes.
Dealing with the various discussion that there was just now over alternatives or what could be done, I'd like to point out that in 2000 there
were proposals for this route to be made a cycle track. That was part of the Safer Guildford initiative. But it was done on the basis that the county council owned the land. Some work was done on that, but it fizzled out and nothing happened to it. So there was a proposal then for it to be a cycle track, which would have meant pedestrians and cycles. I think one of the problems with it was that the requirements for a cycle track then were that headroom should have been 2.7 metres. Possibility of cyclist dismounting, but that was raised then. And when the inquiries were being made for this modification order, Mr. Salaman did raise the issue of a cycle track and granting permission for that on part of our land, but the reply was there that they would wait and see what happened to this before the cycle track, before taking any steps with the cycle track, as it would also involve Thames water. There was also this discussion about traffic regulation orders as far as horses is concerned. This issue arose at the public inquiry over the no entry signs, which were found to be a challenge, the no entry signs which were put up at each end of the order route. And it emerged then that the no entry signs don't apply to horses. It applied to cycles, but apparently you can ride a horse in a street through a no entry sign. There's no statutory company.
Really? Good heavens.
When you were talking about that, that reminded me of we've been there before with that. Yeah. On the case of Lee, which Mr. Wesley has referred to, this case was mentioned in the High Court, and the submissions I made there were that these were litigants in person, and the way they presented the case was that it was a trespass and a civil wrong, but from my reading of it, there was no reference to public nuisance in that case, and from my reading of it, it's really saying that because there were health and safety issues, it was taken in the abstract, and there's no discussion by the inspector or in the actual judgment of the interplay with that with public nuisance, and I think that's an important point. If we hadn't pleaded public nuisance or whatever, we might have been in the same situation as Mr. Lee was. There was also, I'd like to comment on the suggestions about what could be done if or management provisions are necessary so far as horse use is concerned in the future. If essentially there is no alternative for a diversion on this route, we've got the M25, and there's a limited number of routes across from Byfleet or Cobham to the other side, to Wisley, to the M25. There is already a bridleway further to the west, which runs down the way navigation. That route is available, and that runs from Byfleet, crosses over a footbridge over the M25, runs down the canal to Purford and West.
I suppose I shouldn't ask you to give evidence, but
how
far away is this from the subway?
It's about a third of a mile, something like that. It's in sight.
Right.
As I say, we did raise the matter of having a a cycle track along Footpath 3 with the Surrey County Council. We were quite amicable to that. Our concern really with all this matter, as is shown by the steps which were taken in 2012, was the nuisance from motorbikes. If cycles have access, then it leaves that open, and that was a lot of the problem. But so if cycles do have access, there is always the problem of motorbikes already getting access as well, which adds to the problem if there's horse use as well. Because as you'll see from the documentation, there have been problems in the past with motorbikes using the road.
Motorbikes aren't entitled to use bridleway.
No, but they do, my lord.
But they might.
They might, and the
Yes.
documentation here shows the Highways Agency. There's a memo from Highways Agency which in effect says you can't, if cycles have access, you can't prevent motorcycles.
It actually says that.
That's from Map.
They don't mean as a matter of law, I suspect. They probably mean as a matter of fact.
Yes, that's absolutely.
exactly,
Yes, of course they can
exactly.
make. It is an offence already
Yes.
under the Road Traffic Act, and you could make a road traffic order, regulation order as well. But this is an isolated spot, and Mr. Salaman and myself taking photographs of a motorcycle doesn't get very far. But that proposal was made, but of course we've had no comeback on that.
I'm quite happy to give them access to Footpath 3. I'll agree to that. And to take away the fencing, that's causing so much animosity. I'm quite okay with that. I just want to live in peace, and I don't want to be constantly in anticipation of something happening.
So am I right in I think the point was made earlier by my lord, but your real concern is the cyclists rather than the horses, because there aren't very many of them. Is that right?
Well, it's also there haven't been horses. It's an artificial
no, I appreciate
concept.
that. But let me not say
No.
it is cyclists as well. You're concerned about the cyclists.
Well, because their access allows motorcyclists to come through.
That's really your complaint about the cyclists, is it?
Well,
But I mean, if it were just cyclists and you didn't have motorbikes and you didn't have horses, would you still be here?
just cycles. I doubt it, but there is a problem with the tunnel. They would have to dismount because it doesn't comply, and I don't think there's any way of enforcing that. But so far as that, as you're saying, if it was just cyclists and there was no other access from motorcycles or horses, but it's problematic.
I mean, the problem of illegal motorbike use of footpaths and bridleways is it's going on up and down the land, but you can't actually physically stop them except by having an obstacle, such as a locked gate, or something which can be circumvented by a kissing gate or something like that. But if they can commit this offence wherever the way is physically open.
Absolutely.
Yes. All right. Got that.
There's a few more points on this. So far as the point at which you look for the public nuisance, I don't agree with what Mr. Westlake has been saying about this. The landowner's capacity to grant a right of way, that's something which has got to be looked at all the time as the period of user goes through. In the same way as you would look at capacity of a landowner if for some reason dedication couldn't place, if it was mortgaged, if it was leased. That would break the period of, and I think it's exactly the same if the circumstances are that it would become a public nuisance during that period. there's a confusion over, I was saying, well, the right is deemed to have started, granted right at the beginning. But that's a legal fiction. That's an interpretation. You have to look at what there was capacity to dedicate throughout the whole of the user period. And if there was a break, that would break it. And the reversion back is just a legal fiction to say, oh, well, it was granted all the time. What you have to look at is, in this case, it's interesting that the regulations came in 1993 with the horse, with the first time that regulations came in specifying the height for horse equestrian use. Well, that's something which, from that point, can you say that the Department of Transport had the capacity to dedicate, because of those design standards, because of his common law duty as set out in Yetkin, not to cause a danger on the highway. If that's the case at that point, he hasn't got capacity to dedicate. And what's the point of then looking back and saying whether a highway is safe, as in this case, where the horse use was 20 years ago, it's a completely artificial situation. Because just because the way the legal fiction works to date it from the first use doesn't mean to say that you don't have to look at what the risks were all the way through the period of usage. Okay, I don't think I've got anything more to say that covers the points we time.
Can I just say thank you to the three of you? And I've got dozens of letters here which make the point Lord Justice Elias makes, that it is nowhere near safe and is per se a nuisance. And they would never take their horses there. And there's dozens of letters.
Right. Do my colleagues have any questions? No. Thank you all very much for your submissions.
And if anybody has any information, please get in touch with me.
Very interesting case, and we will, of course, reserve judgment, but we will send out a written draft of the judgment. This is not pleased to give you a chance to think of, on either side, of points which you haven't raised before or say that we've got it wrong. It's simply for the correction of typos or get names or dates wrong, that sort of thing. But otherwise, when we send out our decision, that is the decision which we hand down formally a couple of days later. Any questions of costs and so on can be dealt with in writing at that stage. Thank you all very much for your assistance.